Welcome to This Explainer. Today, we're diving into a genuinely unprecedented and incredibly tragic legal battle. We're looking at a high-stakes clash between the supermarket giant ALDI and the estate of a deceased worker. It's a really complex story. It involves workplace trauma, intense legal maneuvering, and a precedent-setting ruling by the South Australian Employment Tribunal. We've distilled all the key details into the slides you'll see today, so let's just get right to it. Okay, we're going to start with a truly shocking premise. What actually happens to a workplace compensation claim when the injured worker tragically takes their own life? Well, in this case, a major corporation attempted to throw out the claim entirely. Aldi's core legal argument was that the worker's death created an incurable loss of evidence. Basically, they argued that because she was no longer here to be cross-examined, holding a fair trial was literally impossible. It's a bold strategy, and it forces us to ask, does death automatically defeat a worker's right to justice? Section 1. The Traumatic Incident. To understand how this unprecedented legal argument even made its way before the South Australian Employment Tribunal, we really need to trace the deeply tragic timeline of ALDI employee Emily Caridi. The source material lays out a rapid, heartbreaking escalation. It all started on July 14, 2023. Emily and a store manager intercepted a suspected shoplifter, and during the confrontation, the suspect spat directly into Emily's mouth. This physical assault triggered profound anxiety for Emily about potential disease transmission, a fear that, medical experts couldn't completely rule out for 3 whole months. And things spiraled quickly. By August, she suffered a severe nervous breakdown and had to be hospitalized. Then, in October, Aldi terminated her employment. Tragically, just 5 months after the initial incident, in December 2023, Emily took her own life. Section 2. The employer's response. Following that initial assault, the narrative splits dramatically into a highly contested he said, she said dynamic between Emily's family and Aldi management. Now, the estate made some truly startling allegations about how Aldi handled the immediate aftermath. Emily and her mother, Rita Sargent, claimed that Aldi completely downplayed the severity of the assault. They alleged management failed to contact the police, didn't file an official report, and took zero photographic evidence. But most notably, according to tribunal records, when Emily was writing her statement, the store manager allegedly instructed her to get it as close to mine as you can. Imagine that. You can clearly see the stark contrast in perspectives regarding the days that followed. A huge conflict emerged over the store's CCTV footage. Emily claimed management essentially taunted her with these protracted, confusing delays to viewing the footage. She described it as psychologically damaging, while she was left just ruminating about the assault. Aldi, on the other hand, completely rejected claims that they were harassing her. When Emily complained of pestering phone calls, Aldi argued their actions were simply a proactive approach to monitor her well-being. So we have 2 entirely different versions of reality here. Section 3. The Legal Battle. This escalating tension eventually culminated in Aldi taking a definitive legal stance. They filed for a summary dismissal under Section 41 of the South Australian Employment Tribunal Act 2014, basically attempting to strike out the workplace suicide compensation case entirely without a trial. Let's break down those legal arguments. Aldi claimed that not being able to cross-examine Emily or subject her to a psychiatric exam created an incurable prejudice. They went as far as to argue she had underlying delusional paranoia and potentially serious alcohol abuse, claiming that that was the true cause of her condition, not the workplace incident. But the compensating authority and the estate fought back hard. They argued that just because a witness is unavailable, that doesn't inherently equal an unfair trial, especially since Emily had already provided these long, incredibly detailed interviews to investigators before her death. Section 4. The Tribunal's Ruling. The South Australian Employment Tribunal eventually handed down its official decision on Aldi's dismissal application. And they completely rejected Aldi's bid. They ruled the compensation case was absolutely not an abusive process. In fact, they pointed out that Emily not being there to testify was actually a much bigger hurdle for her own estate's case than it was for Aldi's defense. The tribunal made it crystal clear. A worker's claim for an injury sustained during employment doesn't just disappear simply because the worker passes away. The justice system would be rightly criticized if that were the case. So let's talk about the penalty, and the crucial number here is 85. Prior to this decision, the Return to Work Corporation had explicitly warned Aldi that their dismissal attempt lacked merit and that they'd face penalties if they continued. But because Aldi pressed ahead with the application anyway, the tribunal hit the retailer with an adverse order to pay 85% of the applicant's legal costs on the higher court scale. That is a massive hit. Following this massive procedural defeat and that hefty financial penalty, ALDI actually abandoned their defense altogether. They voluntarily entered into consent orders outside of court, agreeing to pay backdated weekly compensation from the exact date of Emily's incapacity all the way up until her death. It was a complete victory for the estate.
Section 5, Psychiatric Injury Law. Let's zoom out a bit and look at the broader legal implications of this case and see how it builds our understanding of workplace psychiatric injuries under Australian law.
This case really forces us to ask a vital question. Remember how ALDI claimed Emily's alleged underlying delusional paranoia was the real issue? So what exactly is the legal standard when an employer claims a worker's underlying mental health issues are to blame rather than the workplace itself? Is the employer still legally liable? The answer lies in a fascinating legal doctrine known as the eggshell skull principle. This principle firmly establishes that an employer must take a worker as they find them. This means that even if a worker has a pre-existing vulnerability, like an eggshell skull, if workplace trauma, chronic overwork, or poorly managed bullying worsens that underlying condition, the employer is absolutely still liable. They can't just use a pre-existing condition as some kind of get-out-of-jail-free card. Section 6, Employee Rights and Representation. Now, navigating these deeply complex legal frameworks and standing up to massive corporate entities is exactly why systemic support systems exist for everyday employees. The source material for today's explainer was provided by the Australian Workplace Discrimination Representatives, or AWDR. They're an organization driven by a strong social justice agenda, dedicated to helping everyday Australians find their voice when they're facing daunting workplace battles, just like the one Emily's estate fought. ADWR provides really powerful advocacy and strategic guidance across a super wide range of workplace disputes. We're talking unfair dismissal, toxic workplaces, sexual harassment, or navigating complex general protection disputes. Their ultimate goal is to ensure that employers, no matter how large or well-resourced, are held accountable under the Fair Work Act and equal opportunity laws. Now, it's crucial to clarify exactly how AWDR operates. They are not lawyers, and they do not give legal advice. Instead, they are highly experienced workplace relations specialists. Operating as non-lawyer advocates, they've successfully supported over 16,000 clients across Australia over 3 decades. They step in to mediate, negotiate, and truly represent workers. And their process is highly structured. They don't just guess, they systematically analyze the facts. First, they gather your employment records. Then, they identify the true extent of your claim. Third, they conduct a really detailed investigation of the evidence. And finally, they thoroughly review your contracts. The whole goal is to build a real-life strategic solution to secure the best possible financial and professional outcome for the employee. But if you ever find yourself in a workplace dispute, you have to be acutely aware of this number: 21. Time is absolutely of the essence in the Fair Work system. Strict, unforgiving deadlines apply. For example, if you are fired, you have a brief 21-day time limit to file an unfair dismissal application. If you miss that tiny window, your options are going to severely diminish. Which leaves us with a final thought to ponder. This ALDI case shows just how quickly a workplace situation can deteriorate into a massive, complex legal nightmare. So if your workplace turned toxic overnight, or if you faced a traumatic incident tomorrow, would you know exactly how to protect your rights before the clock runs out? Understanding your protections and knowing that specialized representation exists to fight in your corner might just be the most important career knowledge you can have. Thank you so much for joining me for this explainer, and we will catch you next time.